Good evening, ladies and gentlemen. My name is Kehinde Adegbite. I welcome you to Kenny's School of Law. 2 days ago, I had a discussion with Dr. M.A. Latif on should academics be appointed as judges in Nigeria. And he gave us his own perspective. The video is available on the channel. I urge people who have not watched it to do so, and again to subscribe to this channel, because more videos will still be uploaded so that you get to know of the videos when I upload them. Now, this evening I have with me Comrade Ola Adeosun. Comrade Ola Adeosun is a lawyer. He's a passionate courtroom advocate. I've known him for more than 10 years, and I don't know him doing any other thing other than litigation. So when I had the perspective of an academic, I think it's proper to also have the input of a full-fledged courtroom advocate like him, a litigation lawyer, and that's why I've invited him. So he will also tell us his own perspective on the issue of the appointment of the propriety of appointing academics, law lecturers, as judges in Nigeria, especially judges of High Court, as we recently witnessed. Comrade Ola Adeosun, I call him comrade because apart from being a lawyer, he's also an activist. He's an activist of note. He's an activist one can vouch for. Comrade Ola Adeosun, I welcome you to this conversation. Good evening.
Thank you. Thank you.
Okay. I believe you are hearing me. So I want to kickstart this conversation by reading out who a judge is, as propounded by Chukwudevu Oputa, that is the late JSC. Now I open to my book, that is Learning the Law in Nigeria, page 38 of this book. Okay, this is the way Oputa put it. Oputa said a judge is a barrister who is invited to sit on the bench when he has had a lot of standing at the bar. Comrade Ola Adeosun, do you agree with that definition of who a judge is?
Hello?
Comrade Ola Adeosun, did you hear the reading I just did?
I didn't.
Hello? I read out a definition offered by Justice Oputa on definition on who a judge is. Did you hear his own definition of a judge?
I got that.
Okay, do you agree with that?
I got that.
My question is, do you agree?
Of course, I agree with my Lord Oputa Jesse.
Okay.
I agree with his definition. That's the foundational definition of who a judge should be. Though there are more to it, because activities at the bar may not support the courtroom advocacy. One may be a bar person, one may be involved in NBA activities and not be a courtroom advocate. So like I said earlier on, that should be the foundational definition of who a judge should be. So I agree with my lord.
Okay, thank you. Now, how do you reconcile that definition?
Yes, that's my view. I agree that that should be the foundational definition of who a judge should be. However, I'll just be quick to add that one may be a bar person. One might have given a lot in the course of activities of the bar and not be a courtroom advocate. So, and that was why I said it's a foundational definition of who a judge should be.
So the question is this: how do you reconcile that definition with the recent appointment of academics as judges in Nigeria? Okay. Even though we know that this is not the first time that academics are being appointed as judges in Nigeria, but we have increasing number, maybe this time around. So how do you reconcile that?
For me, I don't see anything wrong in appointing academics as judges in Nigeria. There's nothing wrong with it at all. However, I just believe that if an academic is to be appointed as a judge, such an academic must have been somebody who has been involved in courtroom advocacy, who is vast with the activities in the courts, who understands what advocacy is in its real sense, especially persons coming from our universities. Understanding the fact that in our universities, the law teachers only teaches substantive law, not procedural laws. And even those at the law school, law teachers at the law school who teaches procedural law, for those of us who have been privileged to have passed through Nigerian law school, we also understand the fact that you learn more, you know more about advocacy in the law school or in the university. And most of these things you know as much as I do that law is an art beyond the academics aspect of it. It's an art that you get used to, that you live with. And if you just teach it and you are not involved in the art, coming to the bench may be very, very difficult. In fact, it will be tantamount to risking a lot of things in the lives of the people, especially criminal justice system. When you bring a judge who does not have advocacy experience, who does not have courtroom experience as a judge, it's going to be dangerous for litigants. It will be tantamount to engaging in trial and error with the lives of the citizen. And I can tell you that being a judge is not a campaign party. Beyond the so-called supposed enjoyment that we see on the surface, it's a very tedious job that only people who has good grasp of what happens in the courtroom would be able to do it. Anybody who does not have such background and is appointed as a judge would need at least 2 years to get to understand what is obtainable on the job. And that would be too dangerous an investment to make for the society.
So, comrade, if I get your point very well, what you are saying is that unless a lawyer to be appointed as a judge, has litigation experience, litigation background, that person is not fit to be appointed. Is that the point you are making?
Yeah, with due respect to those who have is correct. If that position is correct, it tallies with my position that it is only somebody who has litigation background, advocacy background, that would be fit, that would be good to be appointed as a judge.
But now, if you now look at your position in the face of the constitutional provision, especially section 271 of the Constitution of the Federal Republic of Nigeria in 1999, relating to two basic requirements for anybody to qualify for appointment as an High Court judge. Number one, the person must have qualified as a lawyer. Number two, the person must have been so qualified for a period of not less than 10 years. Those are the requirements under the Constitution. But the question of litigation experience, because a lawyer can have different kinds of experience, you can also have corporate world experience. So don't you think that would disqualify academics and some other persons, some other lawyers from being appointed as judges?
Well, yes, I agree with you. Section 271 of the Constitution explicitly gives out the requirements for appointment as a judge. But you also agree with me that the NJC, in tandem with the provisions of the Constitution, also sets out rules and guidelines for appointments of judges. And those rules and guidelines are in tandem with the provisions of the Constitution, as the Constitution has empowered them to do. Not just the NJC, even the various states judicial service commissions, pursuant to their powers under the Constitution, also set rules, set certain guidelines for the recommendation of persons to be appointed as judges. So it is only when such guidelines are made, contrary to the provisions of the Constitution, that it becomes illegal. But where such guidelines are made to further enhance that provision of the Constitution, there is nothing wrong with it. And that's why we have those guidelines. I mean, in some states, for example, you must have at least 10 judgments of the High Court before you be appointed within the space of 10 years, before you be appointed as a judge. In some states, all that is required is about 3 judgments of the High Court for you to be recommended by things are only meant to further strengthen the provisions of the Constitution, to strengthen the justice system in tandem with the provision of the Constitution. So there's nothing wrong with it at all. There's nothing wrong with it at all.
Okay. In your own opinion, do you consider an academic who is like 20 years of post-call experience, but who possibly or probably spent the first 5 years going to court as a litigation lawyer, and the last 15 years as an academic, squarely an academic? You don't consider that person to have experience? Okay.
I don't, and I'll tell you why.
Okay.
An academic, especially those in the university, I want you to reiterate that, who teaches strict comparative law, will not know the current state of procedural laws in the various states or in the states where he practices, where he wants to be appointed as a judge. You will agree with me that since 2015, for example, our criminal applicable in our criminal justice system has evolved a lot. A person who, for instance, has not practiced law between 2015 and today, who has not been an advocate between 2015 and today, would have a lot of difficulty in attending to criminal justice system or criminal cases when brought before him, who is not familiar with the applications of the Bureau of Criminal Justice Act or the various Bureau of Criminal Justice laws in the various states of the Federation. So such a person, when appointed as a judge, would naturally, when criminal cases are brought before him as a judge. Now look at the various High Court rules. These rules are being reviewed on a daily basis. Somebody who is not involved in advocacy, in civil procedure, civil practices in courts, will not understand the innovations involved. Gets to the bench. Naturally, we'll start learning on the job. And you know the implication of learning on the job when the lives of citizens are involved, the liberty of citizens are involved. You know, so as far as I'm concerned, somebody who has practiced, who had very good litigation practice in his first 5 years, after 15 years, within that time and 15 years, he wasn't involved. And you want that person, you want to appoint that person as a judge. And no, for me, I do not think that is the best. That's going to be the best for the society. Honestly, I do not think so. That is just the reality. Of course, the law says yes, 10 years post-call. He must have been a lawyer. Then he must have spent 10 years. Are we now suggesting that somebody who practiced law for 5 years and thereafter returns to Alaba International Market, opens a shop? You know, it's always difficult. The first 5 years of practice, it takes the grace of God for somebody to survive. We all know how it is in this country. Now, some persons decides to go and open one bukateria and is making it big there. He becomes a friend of the government. He knows some people in the Judicial Service Commission, and they now recommend him for appointment as a judge after 15 years because he had advocacy practice in his first 5 years. Then 15 years after, he was into business, selling food, or as a shop at Alaba International Market. He became an international businessman, making so much money. But also because he had his first 5 years in advocacy, And because he told you that he has been reading all, you now appoint him as a judge, the society suffers a lot in that kind of situation. So it is not the best. It's not going to be the best for the society.
So, comrade, in your own estimation, am I correct to say that what you have in mind is that for an academic to be qualified for appointment as a judge, then that academic must have had unbroken years of practice of courtroom advocacy? So not
Exactly.
not that you break at any time. You continue to practice
Exactly.
as you also teach in university. You combine the two together. Is that what you are saying?
Exactly. Such persons, such academics who is involved in unbroken litigation practice would give more to the students he teaches than the ordinary academic who just teaches and not go to court. So such persons will be the best for the bench than even those of us solely in practice, in litigation.
Okay. Don't you think, comrade, that importing this requirement, litigation experience, as a requirement for being appointed is not part of the Constitution, even if it is if we can find it in the NJC rules, is an additional requirement which may not stand in the face of the constitutional provision?
Well, I agree with you that the Constitution does not give any other requirements, but the Constitution empowers some people to make recommendations for appointment as judges. Such persons have the discretion to set out guidelines because naturally people who will apply will always be more than the numbers required. These 10 years, I'm not aware of any states or even the federal high courts that requires appointment of 10 judges and 10 judges apply. You would always have more numbers applying to that vacancy. It is now the duty of the recommending authorities in screening those persons to put out guidelines through which such persons will be seen to be better than the other, to be more qualified than the other. And that's the essence of the NJC, the NJC rules, and the various GSC rules of the various states of the Federation, including the FCT. So there's nothing wrong in it. After scaling through all these rules, you still have interview sessions at Abuja with some select committee of the NJC, where certain questions will be asked. And when your knowledge of the law is tested and you are believed not to be worthy, they still drop you despite meeting the constitutional requirements. Can such a person go to court to challenge that position taken by the NJC? As far as I know, I believe that such an action will fail. Nobody will even go to court on that basis. If the NJC says, when we interviewed him, we realized he does not have a grasp of the present state of the law, there is nothing anybody can do. Even if you go to court that they dropped you despite meeting constitutional requirements, no court would oppose such a case.
Comrade, you know that for a practicing lawyer to become a judge, all that practicing lawyer needs is being a lawyer, qualified as a lawyer, and must have been so qualified for 10 years. Okay, luckily he's practicing. But now, if an academic is going to become a judge, he has to have litigation experience as well, in addition to being an academic. Is that fair? So are you appointing him as a lawyer, as a litigation lawyer, or you are appointing the person as an academic? I don't know whether you get the distinction I'm trying to bring. The person has already met the requirements, and you are saying the person should have litigation experience again.
No, I'm not aware of any states where they set out rules to say you must have litigation experience as an academic to be appointed as a judge. I'm just saying personally.
Okay, comrade, please let me quickly read something to you from the NJC guidelines for appointment of judges. This is 2014. I want to believe this is the same guideline they are using till date. Now, there is paragraph 4. We have sub 1 under paragraph 4, then we have A, B, C, D. I will read D out to you. But before D, we have B and C. B, let me read from B. B states, active successful practice at the bar, including satisfactory presentation of cases in court, as a legal practitioner, either in private practice or as a legal officer in any public service. That's the end of that. I move to C. Satisfactory and consistent display of sound and mature judgment in the office as a chief registrar or chief magistrate. Then I go to D. Credible record of teaching law, legal research in a reputable university, and publication of legal works, and in addition to any or all of the above. So what do they mean by in addition to any or all of the above? In my own opinion, I think they are talking about in addition to you have active, successful practice at the bar. Or
not on, or okay.
Or in the alternative, but that's C. I don't know how an academic will meet that satisfactory and consistent display of sound and mature judgment in the office as a chief registrar or chief magistrate. You know, you can't combine the two. You can't be an academic and still be a chief magistrate or chief registrar. But it's possible you can be an academic and still be a legal, a practicing lawyer, a courtroom advocate. You can do that. So this any, in addition to any or all of the above, how do you see that? What's your interpretation of that?
Well, the implication is that you must have any of the previous ones read out together with your activities as an academic. That's the implication. You must have any of the previous ones read out in addition.
What do you mean by what do you mean by any?
Any, you've read out the first one, which is litigation experience, judgments. The second one is being a chief registrar or chief magistrate.
Okay.
I think these are the two.
Yes.
These are the two. So you must have either of these before you together with your academic experience before you be appointed as a judge.
Okay, now, Comrade, without mentioning any specific name, do you consider do you consider appointees, the recent persons appointed from the academics, as having met these requirements of having litigation experience, or you consider some of them not to have met that requirements?
Well, I must be honest with you. I rarely know the courtroom advocacy activities of many of those that has been appointed so far or recommended for appointment so far. So I may not be in a position to really speak about their advocacy records. I know at a point I'm aware that my brother, Professor Elijah Taiwo of Adelaide University, I knew he was involved in courtroom advocacy so well. At the point, I don't know if he's still that involved, but I used to know he was involved in courtroom advocacy so well. I may not be able to know. I'm not aware of the others, the activities in the court. So because I do not, I may not be able to really speak about those that are aware of.
Okay, comrade, if you don't know, how do you now consider this, our conversation, as relevant? Does it mean that in Nigeria, we have not been appointing pure academics as judges?
Well, the truth is, I've had people complain that some persons have not been involved in advocacy, that they are just pure academics and they were just appointed as judges. For such persons, if it is true, if the complaints are true, that they do not have advocacy background, They have not been involved in litigation, courtroom advocacy and litigation. And authorities more to the justice system than they have done good. That is my opinion.
Okay, well, you know that it is also possible that those who think that, or those who said that some appointees have not had litigation experience, that may not also be true. You know that?
Yes, I said it. It may not be true.
Oh, okay.
It may not be true. It may not be true.
So
it may not be true. But if it is true, then the appointing authorities have done more disservice than service to the legal profession, to the justice system, to the Nigerian people as a whole.
So now, in view of the rule that's or the guideline that I read out to you, relating to the requirements, the condition that a person to be appointed from the academics or from the academia must meet, do you now think that your position that the person must have litigation experience is in line with the regulation, with the NJC guidelines? Do you think your position is in line with that?
Yes, it is.
Okay.
It is.
Okay. Now, Comrade, how do you see the performance of those who have come from the academia, who are sitting on judicial, on our benches, maybe High Court, National Industrial Court, Court of Appeal, and Supreme Court? How do you see their performance?
So far, so good. Those who have appeared before have done so well. So far, so good. Those that have appeared before have done so well. And we have records of the Akiola Agudas too. We have records of the Nikki Tobis, and we've read their judgments, and I must tell you, they were fantastic.
But I do not think Nikki Toby was a practicing lawyer before his appointment.
I do not know. Honestly, I do not know.
So, do you really think that, though you have made the point, is it really correct to say that one needs to have litigation experience before you can perform as expected of you as a judge? Does it really
as a judge
necessary? Yes.
Well, I honestly, with my experience on the job as a lawyer, I know as a fact that the art of litigation is an act. It's not something that you just come about. It's something that happens to you in the course of doing it consistently. It is not something you read about. We have seen persons who graduated with first class in the universities, even in the law school, and they get to practice and they mess things up. And we've seen people who graduate with third class and even pass from the university and become fantastic in litigation because they get used to it. They got used to it. They got to love it. They chose the art for themselves. And that is just it. So litigation is an art that with time, although those who I said that have appeared before and that were appointed from the academics, many of these persons probably must have learned on the job. I may not be able to speak about their early days on the bench. Probably they took their time, and as somebody who has come from the academy, naturally they have tendency not have this experience. But the truth is that to the extent that I know about this job, it is not something you just jump into. It's not possible. You'll mess up, you'll spoil a lot of things, a lot of persons will get to cry wrongly before you get it right. And I don't think that is too good for the society.
A judge adjudicates, a litigation lawyer advocates. Are these not two different functions? A lawyer who is an academic teaches and researches and writes and analyzes legal materials, legal information. What you mentioned, Criminal Justice, Administration of Criminal Justice Act, which was introduced in 2015. You know that an academic might have worked on it from the beginning to the end, analyzing it, and may not have any problem in applying that law as a judge. So don't you think that what a judge needs to do on the bench may not really require that you have litigation experience? That given, especially those who are coming from the academia.
I love your choice of words. And academics might have, the implication is that they might not have analyzed those laws. So and yes, most of the time academics have their areas of specialization.
Yes, comrade, let me quickly come in here. When I said might, because I can't be too sure of any particular academic, because they do have their research areas of interest. But you also know that even litigation lawyers, you don't practice every area of law. It depends on areas that clients have brought forward to you. So there are law firms there are lawyers rather, who don't have experience of criminal matters as well. They don't defend, they don't prosecute. All they handle are civil matters. And even civil matters, there are subjects they don't touch in civil matters because they've not been focusing on those areas. But if they are appointed as judges, they will have to deal with all matters. For instance, maritime matter, a lawyer, somebody who was appointed from the bar, who has never handled maritime matter, but has to sit on a maritime matter as a judge. You won't say because you have not dealt with it before, you won't be able to undo it. I think the same thing applies to an academic who may not have all this experience you are talking about, but can, given the fact that the person is a qualified lawyer and has been practicing in terms of classroom work, and I feel the person can still be able to cope. So I don't know if I'm clear enough.
Well, I get you. But I want you to appreciate the fact that in Nigeria today, we are general practitioners. Only very few, extremely few law firms specializes in Nigeria. Virtually every lawyer who is a full-time advocate, who is a full-time litigation lawyer, deals in virtually every aspect of the law. And that is the truth. I'm talking to you from experience. Because probably because of the state of the economy of the country, it is very difficult for lawyers to specialize. And that is why we have reasons to work on. There is a litigation lawyer, a full-fledged litigation lawyer who does not work in a law firm that is specialized, because the truth is that we have some few law firms who are specialized, but a lawyer, an average Nigerian lawyer, is a general practitioner. We are involved in virtually everything, virtually every aspect of law. You have a reason to have to work on it. So in contrast with what you have with the academics, who only researches on his area of specialization. So such an academic, for example, somebody who is an expert, who specializes in criminal law, would naturally work on virtually every material, both relevant and irrelevant, for academic purposes that has to do with criminal law. That you can't take away from him. But when he gets to the bench, he will have to work on much more than that. So he will have to start learning that new role. Unlike that aspect that he has worked on for probably over 20, 25 years of his life, he will now start working on a new line within that period of his appointment. Some doesn't get well with it. Some get to blend along the line. But before they get to blend, you can imagine what litigants and even litigation lawyers would have gone through. Without mentioning names, I've appeared before judges, newly appointed judges. Some, for the first 1-2 years of the appointments, lawyers keep running away, looking for reasons to run away from them. Because they keep learning with people's lives. They keep frustrating lawyers. You would have read your law, you would have prepared, you would have been ready, you get there, you'll be saying the law, the judge will be saying something else.
Okay.
And when the judge was to strike out the application, instead of ruling that the application is struck out, he just struck out the suit. She just ruled and struck out the suit. Everybody were like, what is this? But the truth is that that judge, as at the time she was appointed, she had not practiced law for about 7 years.
Hello, comrade.
So she was to do, I'm with you. I'm with you.
Okay. I think there was some interruption. There was connectivity problem, but you are back now. I'm hearing you.
So a lot of terrible things that happens during their learning stages. These are things we can avoid. It's not applicable to only lawyers from the academia. I've said earlier on, there are lawyers who are in other areas of practice, but not courtroom advocacy. When they are appointed, we get these problems. It is we in advocacy that suffers it most.
So, comrade, are you saying that every litigation lawyer is a judicial trainee? Did you get that? Is a judicial trainee?
Every litigation lawyer is a judicial trainee. Because you're always there. You go there every day. You see what happens there. You see how the judges handle it. You see how these things are done almost on a daily basis.
So those in the academia, they don't have that opportunity. That's the point you are making. So they don't get to study how things are done, what's the way a judge needs to listen, needs to carry himself, needs to do the work, needs to relate with lawyers, things that you have to do as a judge, the way you talk as a judge, the way you conduct the business of the court. So those coming from the academia, they don't have that opportunity. I think you have, that's part of what you are saying.
Exactly, they don't.
Okay, I think you have made the points very strongly. Now, comrade, there is this trend which I have noticed. I don't know whether you have noticed the same. Almost every lawyer now wants to become a judge. What is the point of attraction? Unlike what we read or because I was reading an interview by Are Afe Babalola, where he said that it was judges who used to invite practicing lawyers to come to the bench, and some of them will even turn down the invitation. They will not take it up. So, but now that is not the case. In fact, we cannot even take lawyers who go to court. We can't take all of them who are interested in going to the bench. And we also have those from the corporate world. We have those from the academia. We have those from lawyers. Once you're a lawyer, everybody wants to become a judge. What is the point of attraction?
Well, not everybody wants to become a judge. Some of us don't want to.
I'm talking about many people, many lawyers. I personally don't want to become a judge too.
Now, let me tell you, the truth is this. The economic reality of the country, the economic situation of many lawyers has actually led to that. Go around, look at where our colleagues live. Many of our colleagues are not really making it big. Yes, it's not all that rosy. But people know that the moment you become a judge, certain things are certain by the end of the month. Certain things are certain every 4 years. You get your jeeps changed. you get your wardrobe allowances, you get your, so the perks of office makes it attractive, despite the fact that our judges are grossly underpaid. But when you consider, when you juxtapose it with the earning of the average lawyer on the streets, you agree with me that they earn better. And that is why many of our colleagues are struggling to get to the bench. At least there's security. You know that till you die, there are certain millions of naira that you'll be collecting till you die. So on the basis of that, our people tend to ignore the suffering going on the bench. Because like I told somebody, at least on 2 occasions, I've been talked to apply to the bench. But I always tell them, a former chief judge of my state, of Oyo State, has mentioned it to me. Some senior lawyers, I've always told them, I said, I do not have passion for the bench. That is one. 2, they are not rich. They don't have money. They don't have money. There's limits to how you can earn. There's limit to how you can earn, except those who chooses to be corrupt. When you are not corrupt, there's limits to your earning. There's limit to how you can spend. There's limit to what you can do. There's limit to the kind of support you can give to indigent persons around you as a judge. So for these reasons, I do some things for 1 or 2 indigent persons. And I know that as a judge, I won't be able to do those things again because the earning cannot be enough to take care of those things. So because of that, I just decided that, well, 1, I do not have passion for it. 2, economically, it's not it. And as somebody told me, on one occasion, the senior lawyer told me, look, you earn so millions at least every month. So what are you talking about? You have your cars, you have your driver. I said, look, tell me who makes more money, a successful lawyer or a successful judge? And he kept quiet. So and I told him, I said, the money you earn, can any judge, the money you earn in a year, can any judge earn it from the day of his appointment till the day you retire? I'm not aware of any high court judge that will earn it. And he kept quiet. And that was the end of the conversation. So, but because of the economic reality, how many lawyers are comfortable economically? How many lawyers are able to take care of their family needs, the needs of the children, the economic reality? There's poverty in the land that it has really affected lawyers. So and that is why many lawyers, with due respect to those who just have passion for it. I know some lawyers, I know some persons whom from the university days have always wanted to be judges. So and I know some that has made it so well in practice and still are struggling to be judges. So except for those few ones who has this passion, majority of the hundreds and thousands of persons you see applying to be judges want to be judges because of the economic reality, because of the poverty situation that we all face, not just very few, all of us face this poverty situation in the country. So, and that is just the truth. That is the reality. That's why you have so many persons, even those who do not have passion for the job. And that's why you see some judges, they'll come to court, they'll be complaining, they'll be lamenting, this job is difficult. We have been writing, no government is not doing anything to help us. We have been writing, we have been suffering. Those ones, you know that these ones doesn't have passion for the job. But they just have to take it up because the economic situation was not sustaining their needs. And they see the job as a judge as a certain means of any certain income at the end of the month. That will be enough to take care of at least their basic needs anyway and make them to live big to some extent.
So, Comrade, do you think that as poorly paid as judges are, according to you, that they are still better paid than professors who also find bench attractive?
Yes, I believe so. I know they are better paid than professors who aspire to go to the bench. I know so well that they are better remunerated than professors. not just the basic salaries. When you look at the allowances and every other thing attached, professors don't earn that much. Professors are terribly paid in Nigeria. They are not being paid in Nigeria at all. And maybe that's why our education system is the way it is.
So, no problem. Now, Comrade, will you push for any amendments of the constitutional requirements regarding qualification for appointment as a judge?
Yes, if for now, I don't think there's any reason for that, because nobody has challenged the various states judicial service commissions conditions attached, or the NJC's guidelines. Probably when somebody starts challenging it in future, and we have our court ruling against those guidelines, maybe some of us will start canvassing that those guidelines, some of the provisions of these guidelines should be inputted in the Constitution. But for now, I don't think it is necessary. Honestly, I don't think so. It will be a waste of time and resources. We talk about wasting the time and resources of the country, because it's not necessary. Common sense dictates that certain things are just normal, and that is it.
Okay, now, Comrade, we are moving close to the end of this conversation. But before then, let me put this to you. Now we have read out the provision of the guidelines, Rule 4. If you look at this rule, these categories of lawyers who can be appointed as judges, you will notice that we have practicing lawyer, the lawyers at the bar. We have lawyers as legal officers in public service, that is Ministry of Justice. We have chief registrar. We have chief magistrates. Then we have academics. We don't have lawyers who work in the corporate sector, in the private sector, like in banks, legal advisors, in companies as legal advisors. We don't have lawyers who work with some international organizations, lawyers who work in different capacities. We don't have them. How do you see that?
Why yes, we cannot have them. It is believed that lawyers in academics are allowed to engage in private litigation practice. But lawyers in private employments are stopped by the rules of professional conduct. Lawyers who are on salaried employment are stopped by the rules of professional conduct from engaging in litigation practice. And by implication, they cannot, because you don't have litigation experience. You cannot meet up with the provisions of that guideline by NJC for you to be appointed as a judge, because there's no way you have litigation experience if you are in salaried employment, because you cannot practice.
So you don't think that those ones, that the rule
it's just logical that they cannot be appointed.
So you don't see the need for liberalizing the space, so that those ones can also come, you can accommodate them, and our bench will become richly diversified.
If I start canvassing, if I start arguing that they should be accommodated, I'm sure you yourself will start asking questions that this man has just said that somebody who does not have litigation experience should not be appointed as a judge. And is now saying somebody who cannot even have litigation experience should be appointed as a judge. It will be contradictory. I can't post such opinion. I can't. If you know you want to go to the bench, then resign from that private practice, go into litigation, get litigation experience, courtroom experience, then you can now come and apply as a judge.
So, Comrade, you are not one of those private legal practitioners who hold opinion that academics, law teachers must not be allowed to practice, that it is contrary to the law.
Oh, no, I do not. I'm not one of such private practice. I'm not one of such litigation who would hold that opinion, because there is no way you'll be teaching something that you are not involved in. For me, it is just abnormal. I have to allow academia to practice, get courtroom experience, understand what is available, then you go back to class to tell your students. It betters the loss of your students. It makes your students better. When they go out on firm grounds.
Comrade, are you saying you've not come across great law teachers, accomplished law teachers, who don't even know how to move a motion, who cannot address a court, who have not been involved in litigation, apart from when they were doing attachments from the law school, courtroom attachments, court attachments from the law school, who have not done anything in court from the time of their call, but they are great teachers? Have you not come across them?
I've come across fantastic teachers, but when they get to the courtroom, at times they just mess things up, and you ask yourself why. Because they rarely go to court anyway. So once in a while, when they just go, maybe one after 3 years, they just model things up, and everybody gets embarrassed that, oh, Professor Lagbaja, why? We've seen it happen. I personally have seen it happen severally.
Comrade,
they are fantastic teachers.
Comrade, is quite interesting discussing these subjects with you, and I think you have really done well. It's something is just coming to my mind that I should throw this before we close the conversation. It's occurring to me to say, does it mean that private legal practitioners feel threatened and feel that their chances of becoming judges will be reduced as long as academics are also being made or being appointed as judges in Nigeria?
You see, my brother, let me tell you, the truth of the matter is this. To the extent that some of us have seen in this appointment of judges thing, no private practitioner, but for anybody who understands the way this thing happens, I doubt if any private practitioner will be threatened that people in the academics wants to become judges or are becoming judges. I'll tell you why. The appointment of judges today in Nigeria is determined mainly by persons in the system. It is not about how good or how better you are than the other. Many of the judges that have been appointed are not better than those that are not appointed now. I'm sure you know this. Many people know this, but they just decide to keep quiet. We keep quiet about it because we are powerless. It is either the governor determines who is appointed, the chief judge gets his own slots, the attorney general gets his own slots. I mean, these things are shared. But we may just choose to pretend that we are not aware. They share it amongst themselves. There was a state where 2 judges were appointed in a year. And I mean, on investigation, we got to realize that it was the wife of the governor of that state. Like one person to be tried to be represented by one person, but the wife of the governor picked the 2. I mean, and everybody kept quiet. So that is the reality. So if the governor says I want somebody in the academics, there's practically nothing anybody can do about it. I mean, if the attorney general if the governor consists the attorney general that you can pick, and they pick somebody in the academics, if they want to pick 5 and they pick 5 from the academics, everybody will just be lamenting. I mean, so they have a way of doing this thing. But we are just talking of how it should be, not what is obtainable. If we are to talk about what's obtainable, if they are picking 5 judges, the 5 may come from the academics if the governor wants it that way. And there's nothing anybody can do about it. That is our reality. That's our present reality. One of the reasons why the justice system is the way it is today. So it's not, we are talking about how it should be. I think the essence of this discussion is to talk about how it should be, not what is obtainable. I mean, if it's about what's obtainable, if you have told me, oh, the discussion is about what's, I would have told you it's not necessary. It will be that amount of waste of time. So I don't think it's that some of us are threatening about what I'm not interested in being a judge, for example. So, however, assume it's been done the way it was being done before, where judges recommend person, and I mean, the procedure is so open. I mean, they just look at you and say, oh, this person can do this. And they bring you in. You know, they recommend you, they reach out to you, come and apply. I mean, we still see it happen. But the truth is that out of every 100, maybe it happens in one instance. But that's not how it is now. That's not the reality is that maybe out of 100, you get one of merit that, oh, this person should come to the bench. So that is, so it's not about somebody being threatened. Oh, no. We are talking about how it should be, not how it is, not what is obtainable. You and I know what is obtainable, unless we just decide to pretend as if we don't know.
Thanks, comrade. I really appreciate you. I've really taken much of your time. I never knew the discussion would be this long. So let me leave you at this point. You have done very well. Thank you. Thanks so much.
Thank you so much. Thank you so much for having me. It's a privilege and I appreciate it. I don't take it for granted.
You're welcome. You're welcome. Bye.